Good morning, everybody. Happy Sunday. The sun is shining over here in Michigan. It's great to see. And it's great to see everybody coming and joining in today's show. I know that a lot of us are going through the withdrawal. After all, we were expecting Thursday to be a half day or a half day, as Judge Cannoni would like to say. And unfortunately, it didn't happen. So we had an extended weekend, Thursday, Friday, Saturday, Sunday, and tomorrow, Monday, is going to be an off day for court. So we gotta keep the addiction, and we gotta feed our addictions properly. So that's what we're trying to do here. And of course, no better way than with our guest today. So that's still going to be a staple, hopefully, as this trial continues. We'll see how much longer we have to this trial. So I just do, before we bring in our guest, I don't know if you all got to see, we did have Mark Betterow on, I think it was Friday. And that was a great show. We had a great conversation. There was so much to talk about. And he knows this case backwards and forwards, inside and out. And unfortunately, with what's going on now, with all the publicity, a lot of people are jumping in now, and they don't know exactly all the details. There's a lot of details in this case to keep in mind and keep track of. And in fact, even if you mention one thing about this case and you mention an argument, son, you'll get some other people who know some other facts of the case and throw them at you. And you can't always talk about every single fact of this case and every single detail and explain it, everything like that. But it was a great conversation. So if you did not get to see that, definitely go check out that show that we had with Mark Betterow on Friday. A great conversation, I think, that we had, the two of us. Now, some people are speculating about what we have planned tomorrow. And I do want to burst some of your bubbles. It is not going to be with Lawyer You Know. I know that Lawyer You Know has been making his rounds, interviewing or talking to or having conversation with some other law tubers like myself, but it's not going to be with me. So I'm sure we will eventually collaborate at some point. So it's just not going to be tomorrow, I don't think. So that, just wanted to let you all know that. But we still have something planned tomorrow. I got to really get to work on it. It may not be a guest, but it's something that I'm working on putting together, a video of sorts that obviously has to do with the Karen Read case. So we'll see if I can get around to that. Hopefully we'll get that out to you tomorrow sometime to feed that addiction of yours. And just let's keep in mind that we have about maybe another week, 2 weeks to this trial. The reports are, as we sit here today, that the Commonwealth, Hank Brennan's only going to call one more witness and not some other witnesses. So we're going to definitely talk about that with our guest also today. But first, we got to get into some other issues that we need to discuss today as well. So without any further ado, let's welcome back Brother Counsel, national trial lawyer Solomon Radner, who actually is in Michigan today. I'm not sure what his schedule is for the rest of the day. Maybe we'll hear about that. But here we go. Solomon, welcome back to the show on this Sunday, May 25th.
Thanks. It's always nice to be here.
You have anything exciting planned this week? Are you going to be in town?
I think I am going to be in town this week. I haven't checked my calendar yet. I know that I've got a couple of things scheduled for today and tomorrow, but I haven't really looked past that. I don't think I'm leaving town this week.
Okay, well then you owe me a few lunches, so I'm going to make sure to call you on that.
Fair enough.
Okay. All right. Well, the first thing I want to jump into with you, actually, and you guys, you can start putting the questions in. We'll try to get to them as soon as we can. But the first thing I want to talk to you actually is something that not a lot of people are talking about. So it's a detail. I think it's an important part of the case. And so let's jump into it. There's a witness called Andre Porto, and he testified. He was a DNA expert. And something that he was analyzing the clothing of John O'Keefe and the jeans and all that stuff. So one of the things that he mentioned, and kind of just mentioned it, I think Hank Brennan did it, he wanted to bring this fact out. And let me just set the stage for this. There is some questions, obviously, about how this all went down. That's really the ultimate question that the jury's going to have to figure out. Well, I should say the jury doesn't have to figure it out. The jury just has to figure out whether the Commonwealth proved their case beyond a reasonable doubt, but let's not get into the details of that. Semantics. Yeah. Question here is like this. John O'Keefe was found, and he's got these holes in his T-shirt and his light sweatshirt. And according to the defense's theory in this case, he was attacked by a dog. As you saw yourself, that picture of his arm, you've seen a number of times. You've had some comments about that, what the jury's going to think about that. And definitely can make the argument that he was attacked by a dog. Here's the problem. If he was attacked by a dog, then that T-shirt and that sweatshirt was swabbed for DNA for a dog. They did not find any DNA for a dog, but they did find some pig DNA that sometimes dogs eat some treats that have some pig in it. Okay. Well, in Andre Porto's direct examination, the question here is that, well, you know, that clothing did not immediately get to the lab. And there's some questions about whether the DNA was contaminated. Maybe there was dog DNA there, but it was contaminated along the way before it got to the lab. And what Andre Porto testified to, and I think this is why Hank Brennan brought it out, is the fact that sometimes cold can actually preserve the DNA. So the fact that John O'Keefe was lying outside in the snow could actually be a way of preserving the DNA, and therefore there shouldn't be any of these arguments that the DNA was somehow contaminated because, you know, after all, he was in the snow and the ice and whatever, the cold weather could preserve the DNA. So the question I have to you, Solomon, is that what happened after with those pieces of clothing, and I know you're familiar with DNA and how DNA can get contaminated. I'm sure you've made those arguments before. Here you have DNA from the T-shirt, the sweatshirt, and it was, by all accounts, sopping wet. It was thrown in the back of an ambulance. Then it was thrown in the back. Then it was thrown in the hospital room where somebody was unbagged in the hospital room. Actually, somebody even came in and testified that the clothing there was sopping wet and there was some debris on top of it, or debris noticeable. Eventually, it gets bagged by an individual known as Michael Proctor, and it gets brought back to the Canton PD. It gets laid out on butcher paper, and then it's sitting there for about 3 weeks, 3.5 weeks, before it gets submitted to the evidence lab where they start doing this swabbing. So how strong of a point do you think it is by the fact that the DNA or this testimony that cold can actually preserve DNA? How far do you think that would go with this jury, considering also the trip that these clothing took before it got to the evidence lab?
So anytime you're looking at a DNA sample, you have to ask yourself if it's contaminated or if it's clean. And if it's been contaminated or had the opportunity to be contaminated, then that's certainly more question marks than answers. In this particular case, my understanding is that these clothes were in the possession and custody and control of the boogeyman. He had custody and control of these clothes for several weeks before any testing was done. And obviously the boogeyman, we all know, is Proctor. So the fact that Proctor had access to these clothes, I think it creates a big question mark about anything that was found on these clothes after he had custody and control of those clothes for as long as he did. The jury's either going to believe that Proctor acted appropriately or not. If they believe he acted appropriately, frankly, I don't know what they're smoking. If they believe that he was acting improperly from the very beginning and that this was never an investigation but really a cover-up, which I think the evidence really supports at this point, then anything that's found or not found on clothes that was in his custody and control for that long is meaningless. So the lack of DNA or whatever DNA was left there, whether it's pig DNA or no dog DNA, I think doesn't do anything for anybody, because any samples that were taken were already contaminated by the boogeyman for 3 weeks.
And you would say that would in itself create some reasonable doubt?
That would absolutely create reasonable doubt. Look, anytime we have question marks, it's good for the defense. This creates more question marks than it does periods. The prosecutor has to get rid of question marks and create as many periods as possible, meaning this is a sentence, this is true, this is a fact, as opposed to this is a question. The more question marks there are when the prosecution rests, the stronger the likelihood of a not guilty verdict. So by saying there's no dog DNA on these clothes, and then the very next follow-up question or point that the defense make would obviously be, well, who had those clothes for the 3 weeks before it was tested? Oh, Proctor. Proctor. Okay. All right. Thank you. That's all. Nothing further. And then that completely obliterates anything that the prosecutor would gain by establishing that there was no dog DNA on those clothes. Because, by the way, if the defense is right, whose else DNA is going to be on those clothes? Probably some of the people in that home, right? We've heard these names before. If there's Albert DNA or Higgins DNA or other people's DNA on those clothes, and Proctor knows that, again, that's a big if, that's going to give him good reason to completely try to clean those clothes of any DNA, not just of dog DNA.
Right, I got you.
So the fact that there's no DNA, I think, is meaningless for the prosecutor.
Let me ask you another question, which just came into my mind right now, and it's something that I would definitely see you doing when you're in trial. I've never seen you actually do this directly, but it's something that I keep noticing Alessi doing, and he got shut down a few times with this. He got away with it one time, and then since then, Judge Cannoni does not allow him to ask that question. And that is when anytime that there's some sort of question that he has with the authenticity of something, he'll ask this person on the stand, so you have a doubt about that? And then the person will say yes. And then he'll say, would you consider that a reasonable doubt? So it's been objected to, and Judge Cannoni is sustaining the objection. What do you think about that line of questioning when you have someone on the stand, they're talking about something, there's something that they don't know or can't say for sure, and they're doubtful about it? Is there anything wrong with saying, well, you have a doubt about that, right? Would you consider that doubt reasonable? Is there anything wrong with that line of questioning?
There's absolutely nothing wrong with that line of questioning. It should absolutely be allowed. And this is sadly another example of Judge Cannoni making rulings that help the prosecutor and not the defense. Improper rulings, in my opinion. Those are certainly very fair questions. If anybody says anything, matter of factly in trial, you're of course allowed to ask how certain they are that what they're saying is true. If somebody says the light was green, you say, well, how sure are you about that? I'm not really sure. Well, are you 50-50? Are you 80-20? Are you 90-10? Give us a ballpark. Give us an idea. You're absolutely allowed to do that. Do you have any doubts as to whether it was green? Are those doubts reasonable? Do you think it was more likely than not? Which obviously is the standard that you and I are more used to, which is in civil court, the preponderance of the evidence. Those questions are absolutely permissible. There's no reason in the world that the judge is not allowing them. And sadly, she's not making her rulings on the record. So she's not explaining why they're not allowed. It's all done at sidebar. The only way we'll ever find out is if a transcript is made public, if there's an appeal. And that will only happen if she's convicted.
Do you feel like it's more like getting into the province of the jury where you're asking an ultimate question, which we know we've heard those objections made all the time? You're saying, oh, there is reasonable doubt, and therefore you can argue to the jury, this expert said, or this witness said that he has reasonable doubt, therefore you should find reasonable doubt. Do you think there's anything like invading into the jury's province by asking those type of questions?
No, because we're not dealing with like an expert who's going to opine as to the underlying theory of the case or what has to be proven. What you're doing is you're asking a fact witness how sure they are of what they're saying. There's nothing wrong with that at all. I've done it before. I've never had this objected to. This is a completely improper sustaining of the objection. There's no basis for it.
Okay, there you go. So let's move on to one other issue that this person testified to, and this is also an interesting issue, and that is, again, the defense's case here is, or their theory is that
let me just back up. You're not asking, do you have reasonable doubt as to her guilt?
Right.
That would be an improper question. You're asking, oh, you're saying whatever it is you're saying, are you certain about that fact or do you have doubt? And that's why it's not the underlying question. It's very similar to the underlying question, but you're not asking the underlying question. You're asking a very specific question about how certain they are of the testimony that they're giving. You're not asking an ultimate question. That's just the difference.
Right. Okay. Yeah. I
it's
thought
not like
that
you're saying, it's not like you're saying, well, do you have reasonable doubt as to whether Karen Read is guilty? That would be an improper question, perhaps.
Right. Okay. So
moving to ask, frankly, but no, as far as the facts that they're claiming, you're absolutely allowed to question how certain they are in what they're saying
and how doubtful they are.
Right. 100%.
Yeah. So moving on to another issue, which is also this expert brought out, was the fact that on John O'Keefe's right and left fingernails, there was no other DNA other than John O'Keefe. Now we know, and Solomon, you're very familiar with this, that when you have some sort of altercation, sometimes you can find the other people's DNA under the victim's fingernails because there's some sort of fight, and sometimes they'll scratch and they'll get some of the person's other DNA. This also came out with Andre Porto that there is no other DNA under his right and left fingernail. How strong of a point do you think that is for the Commonwealth to kind of debunk the defense's theory in this case that there was a fight?
Okay, so this is interesting. If, for example, there was DNA of somebody who was inside the house under John O'Keefe's fingernails, that would establish pretty much without a question that there was a fight of some sort. Of course, it could be that, the prosecution may say, well, he just asked him to scratch his back or something. I don't know. But if there would be DNA, that would certainly help the defense a lot. The lack of DNA, I don't think helps the prosecution as much as they're trying to portray, because all it means is that there was no scratching. There could be plenty of fights or plenty of attacks where no scratching takes place. If there's closed fists, if there's somebody getting hit over the head with something, if somebody is body slammed or knocked down some stairs or whatever it might be, if somebody's attacked in a way that they can't scratch you, or if you're wearing clothes, thick clothes, if you're wearing a jacket and somebody tries to grab you and they're grappling with you, there's not going to be DNA under your fingernails. There would be if you're not wearing sleeves, if you're not wearing a shirt, if there's that kind of a wrestle or a fight. But there's too many possible scenarios here that this could have happened inside the home as an attack without there being any fingernail DNA under John O'Keefe's fingers. So I don't think this helps the prosecution at all. I think it's a non-issue.
Right. Okay. So these two issues, the fact that the cold is preserved by the DNA and the fact that there's no other DNA on the right and left fingernails, these are more of like a red herring. And it's not really going to convince the jury definitively that there was no altercation or struggle inside that house and that home.
Right. But for different reasons, because the clothes were in the possession of the boogeyman for 3 weeks. So any testing that was done after that is meaningless, in my opinion, unless they established that Proctor was being sincere and truthful and honest the whole time, which I don't think the prosecutor can prove. But that's what they would have to establish in order to say that anything that was in his control is meaningful. As far as the lack of DNA evidence under the fingernails, that's a completely different point. But yeah, I don't think it helps the prosecution all that much, because all it says is that there was not this particular type of struggle. There could have very easily been a fight, a wrestle, anything else, just that they were fully clothed, or that they attacked him before he had a chance to scratch, or that there were fists. If you're throwing punches with fists, there's not going to be anything under your fingernails. So I don't exactly prosecution.
Okay, great. So I'm going to get into something that I know a lot of people want to see your reaction to. This has to do with an expert that was called by the Commonwealth, and
Burgess.
We spoke very generally about him.
This was hilarious.
So I want to play the clip for you. But we spoke a little bit about this guy because there was some argument, I think maybe it was last week or 2 weeks ago, about whether his supplemental or amended report that he came up with in the middle of trial should be allowed in, and if he should be allowed to testify to all these additions or changes or amendments or supplements, whatever he wants to call them, that he brought into the report. Now, I remember you saying at the time that you don't believe that any of that should come in, which I can't say I disagree with, because they're in the middle of trial. You can't start amending your expert report, right? So that's kind of what we spoke about. That's how we set it up. But now he actually took the stand in last week, and I'm going to play for you some of the cross-examination that came out, and then you can give everybody your reaction. So you can just ignore
it. Let me just say one more thing. I said all that before I knew just how much dirt they had on this guy. If the judge would have said, okay, he can't testify, that's no good. The defense wants this guy to testify.
Exactly.
This shreds them. Okay, go ahead, play it. I'm jumping.
Okay, so this is the beginning of it, and we'll get to a few, like 2 clips of this, and then let's see what you have to say about this.
You have a public profile that's published on Aperture's website, correct?
Yes, I do.
And it's in the form of a biography page?
Yes, I believe so.
And that biography page has your education listed?
Very possible, yes.
Very possible. He's pretending like he doesn't know.
And now he's going to show him,
because he knows where they're going.
That document.
Yes, I do.
And indeed, that is the bio page that's published on Aperture's website, correct?
That is what it appears to be, yes.
Now, I would like you, sir, to turn to page 2 of that document.
Okay.
And I'd like to turn your focus to the bottom of education head. It states, am I correct, sir, BS, Mathematics, and Business Administration. Is that correct?
It does say that, yes.
And there is no qualification that is currently pending. It states BS in Mathematics and Business Administration, correct?
That's what it states there, yes.
And you do not have a Bachelor of Science in Mathematics and Business Administration, do you?
No, I do not.
So that was his first point. That look right now. Let's just ignore that guy. Let's just ignore the guy who's talking for a second. Strike the next. And if you go, we're going to find.
Notified within the last 72 hours.
Listen to this.
Notified. Were you notified within the last 72 hours that someone from the defense accessed your publicly available or viewed your publicly available LinkedIn account?
No, I was not aware.
Okay, so he's saying that he's not aware that within the last testifying, you want to. He's had somebody look the last 70 continue.
Hours that hyperlink on Aperture's official website was disabled?
No, I was not aware.
Are you?
So Solomon just he has his LinkedIn profile, which is there's a hyperlink on Aperture where you can go to his LinkedIn profile, and within the last 72 hours before they was testifying, the defense looked him up. They saw all this stuff, and then all of a sudden the hyperlink becomes inactive, and they're not able to click that. If you clicked it, actually, when I don't know if they updated by now, but when I was actually making this video, I clicked that, you couldn't even see his LinkedIn profile. It was completely shut down and taken down. So now we have just two things. Well, we're almost done yet. We're almost done. But we have number one on the Aperture website itself. It lists him and has a connection. There's a hyperlink to his CV, and in that CV it shows that he has a bachelor's. Then they also have this this hyperlink to his LinkedIn profile. The LinkedIn profile was mysteriously taken down. And then listen to one more part, and then we'll talk about it.
Aware that
And there's a
from
give me 1 second. And 18 there. You are. We just
the
have
first
to.
line, it says in the right underneath BG. I'm sorry, let's strike that. If you look under education, the first line, it says in the right underneath BGS. Do you see that, sir?
I do, yes.
And then to the right, it says Bachelor of General Science in Mathematics and Business Administration, University of Alabama - Birmingham, Alabama, 2022. Did I read that correct?
Yes, you did.
And up in the upper left-hand corner, there's a photograph.
Yes, there is.
Is that you, sir, in the photograph?
So he's actually showing him right now a print. Hold on.
Business
Ignore that guy in the
spelling of
left
your
for a
name,
second.
spelling of your name with one N, correct?
Correct.
And that's the correct spelling of your first name with one N, correct?
Yes.
So that's definitely you represented in this document, correct?
Yes, that is correct.
Now let's look at the first line that relates to education. It states Bachelors of General Science in Mathematics and Business Administration, correct?
That is what it states. Yes.
And the date is 2022, correct?
Correct.
So this document represents that you received your Bachelor's of General Science in Mathematics and Business Administration in 2022, correct?
That is what it states, but there are a number of errors in that. Yes.
Correct. So let's go on. So this is the third example. Am I correct, sir? Well, let me, may I put your honor?
Yes.
And a CV that is linked directly from Aperture's website.
I do not know. I would have to look and check that.
So as you sit here today, you are not able to state whether that CV is linked directly from Aperture's website.
Correct.
But you can go ahead and look for yourself. You click on that hyperlink you're looking at.
So this is a third example of a document that incorrectly states that you have a Bachelor of Science when you do not possess that degree, correct?
It has errors or outdated information. Correct.
Well, when you say outdated, how is it that you can call a date outdated next to something that you don't possess?
I don't understand your question.
Well, you just used the phrase either incorrect or outdated. I'm trying to understand your statement that it's
Sure. So
outdated. Isn't it either you have a Bachelor of Science degree or you don't? Is it?
I have represented I do not have a bachelor's degree.
Correct. But in here, it's represented that you do, correct?
Yes, it is
All
an
right.
error. Yes.
So are you, let's look at what the name is that are on these documents. It says Bachelor of General Science in Mathematics and Business Administration.
So the first thing that he's establishing.
Are you aware that there's no degree at the University of Alabama, Birmingham called a Bachelor of General Science in Mathematics and Business Administration?
Yes, I am, and that is
Okay, so I think you get the point. So now there's not even a degree, even that degree doesn't even exist, right? So Solomon, I mean, he doesn't have a bachelor's. Aperture website says he's got a bachelor's. He's got a link to his CV. All of a sudden, the LinkedIn profile is taken down. You can't connect. So what do you say? What's your reaction to this witness? And just give us your reaction.
I think this was an absolute annihilation of this expert. And what was funny about this was before the defense asked a single substantive question, they established to the jury, you cannot believe a word that this man says. Because whether he has a good explanation for it or not, the perception to the jury, I think, will be this man and this company are willing to lie to get money from lawyers like Hank Brennan. That's all there is to it. Now, they may be wondering whether Hank Brennan knew that this guy and the company were lying, but there's no question, there's little question in the jury's minds, in my opinion, that this man and this company are willing to be dishonest to get money. Once you establish that, the opinions are meaningless, absolutely meaningless. Because once you have established that somebody can't be trusted, it doesn't matter what their opinions are. That's all there is to it. Like, for example, if let's say you have, and this is something that you may recall, there was once an expert, a very famous expert in Michigan, notorious, I should say, who one time made a statement, something to the effect of, I would get up on the table and dance naked for $1,000. And he threw that out tongue in cheek one time during a deposition. And this transcript went flying all around to every lawyer who ever had to cross-examine him. Because then they would say, no, you're getting paid more than $1,000 for this case, right? Are you being truthful? Yes or no? Well, you previously said that you would dance naked on a table for $1,000. So anyway, this guy basically had to stop acting as an expert because they had this dynamite on him. It doesn't matter what your credentials are. It doesn't matter how truthful you're being. Once there's that testimony, you're done. And by the way, I'm looking at this website right now. I'm looking at ApertureLLC.com at Shannon Burgess's page. I just pulled it up while you were talking. One of the things that he forensically investigates is fraud. So
that was a nice nugget there for
I think a
cross-examination.
line of questioning, a really fun line of questioning, would have been something to the effect of, Mr. Burgess, you've investigated fraud before. When people are committing fraud, do they admit that they're committing fraud? What kind of things would you look at to determine if somebody's committing fraud? And then have them list the things. And then write them down in front of the jury on a big board. And then say, now let's talk about you. Did you do this? Because it's going to be, is he willing to be dishonest? Does he have a reason to be dishonest? Does he gain anything from dishonesty, or is it a mistake? Right? So you could kind of go through that, have him show you the elements of how you would determine if somebody is being fraudulent, and then turn it around on him in front of the jury and establish that according to his own definition, they have reason to believe he's committing fraud. I actually just did this in a case recently where there was a witness who tried to change her testimony at trial. And I was able to get her to admit that a reasonable trier of fact might believe that you're just making this up to help the defense. Right? And she said, yeah. So it's a real problem.
So his explanation on redirect, where Brennan tried to rehabilitate him, he asked him about, well, how big is Aperture? And he said, oh, it's like 100 experts work for Aperture. And are you in charge of the website in any way? And he's like, no, of course I'm not in charge of the website. So he said, so as far as you know, they may have just gotten your information from somewhere else other than you. Maybe they got it from your LinkedIn profile, which you just haven't updated in 20 years. And that was kind of the explanation how these kind of things can happen, because when you work at a big company, they don't ask you individually to look over your CV and your education to make sure it's accurate before they post it. How believable and credible do you think that type of argument is? Because I know you worked for a big company once. How credible is that type of line of questioning? Well, they just do whatever they want. They don't really ask me before they post my credentials on their website.
Absolutely not credible at all. I've got his website pulled up right here on another screen. There's a tab for education. Right now it says AS, computer networking. Okay, so they fixed it. Very smart. Professional certifications, 1, 2, 3, 4, 5, 6, 7, 8, 9. There's 9 things listed here. Where do you think Aperture got that information? Where do you think they got that information? You think they got it from all these individual certifiers? Or do you think that Burgess provided it to Aperture? Next, work experience. You open this up. There's 2, 3, there's probably 10 or 12 bullet points here. Where do you think they got this information? Do you think they just made it up? Of course not. He provided it. Memberships, capabilities. Well, all this information comes from somewhere. That's part of when you make a profile and you join a company like this. One of the things the company asks you is, what are your credentials? There's no, you think that Aperture, does anybody, any trier of fact, any juror, anybody watching the show, anybody who hates Karen Read and thinks she's guilty, does anybody think for one second that Aperture just looked at him and started making stuff up about him? Oh, he probably has a bachelor's. Let's write that. Oh, he's probably a part of this professional organization. Let's write that. Of course not. He provided it. And as long as he was making money, this is going to be the perception of it. As long as he and the company were making money off of that, they felt no need to correct it. Now that they've been caught, internationally and drawn and quartered practically in front of a jury. Now they fixed it. Good for them. As far as I'm concerned, and I think as far as the jury is going to believe, this person and this company have absolutely no credibility at all.
And just one other nugget that I forgot to tell you, Solomon, is that now in the CV that he submitted to the court, and by the way, there was a federal case, you know, where you have to, you're familiar with the federal system very well, that you have to submit your experts, expert disclosures and their CV. So they actually, Alessi pulled up a federal case in which he was listed as an expert, and they submitted this same CV with the bachelor's listed there. So he said, well, I didn't submit it, you know, it was my company submitted it, it wasn't me. And, you know, in this case, I submitted an accurate one. And then on top of that, he puts in that he's pursuing this bachelor's degree. And you may not know, Solomon, that he's been pursuing this bachelor's for 17 years.
17
and
years.
I was waiting. I was waiting for the cross-examination to take a turn where, let's see, you know, you said that you're pursuing it. Well, what did you do this past year in order to pursue your bachelor's degree? Did you take any classes this year? How about last year? How about the year before that? You know, and that whole avenue didn't get opened up. But the point was made that he's been allegedly pursuing this degree for 17 years.
Right. Look, there's the main point here is, did the defense lose out on some points by not continuing to just absolutely eviscerate him on this? Maybe. But at that point, at some point, you're beating a dead horse. At some point, you just got to move on. If the expert is completely shredded, he wrote down that he has a bachelor's degree that doesn't exist. How much more? You can't be pursuing a bachelor's degree that doesn't exist. And that's what he said he was doing for 17 years. So again, this is like I told you once before that if you have an expert that's trying to convince the jury that the earth is flat, all you have to do is get out that he's trying to convince the jury that the earth is flat. You don't have to do anything else. So once you establish, oh, so you're telling people you have a bachelor's degree, and now you're telling us that you've been pursuing it for 17 years. Got it. Thank you. That's it. You made your point. Whatever points you made that he's being not truthful, you got. Absolutely got it.
Lena on me asks, why do you suppose the prosecution even used this gentleman?
This is, I think, another major strategic mistake by Brennan. But here's the truth. The truth is, I've used experts, many experts. You've used many experts. And when we look at their CVs and resumes, we assume that they're telling us the truth. Right. If this would happen to one of my experts on the stand, I'd probably end up suing that expert for fraud. Okay? The Commonwealth, I think, if they didn't know about this, I think they can probably sue Aperture and Shannon Burgess for fraud, because they only hired him based on this information. And they would argue, if they wanted to, that they only hired him because of this information that was provided specifically with the intent of convincing them to hire him because of this information. So I think Shannon Burgess has a world of problems ahead of him. Aperture potentially has a world of problems ahead of themselves. And whether the Commonwealth knew about it, I'd be very surprised if Hank Brennan actually knew about it. So he probably assumed that this guy actually had a bachelor's degree. And
here's a
mistake.
Here's a comment from there's a YouTube video where he, assuming Burgess, speaks about imposter syndrome.
You got to be kidding me. How did the defense not find that? Did the defense preserve the right to recall him?
I'm assuming he's on their witness list, but like you said, they probably felt like they already did their job on him.
It's almost at this point, and of course the defense hasn't even gone yet. There's so much reasonable doubt in this case. Again, I think it's questionable if this case survives a directed verdict motion. I really do.
Yeah,
I think it will, because I don't think this judge is going to kick it. But I think that a sincere, fair judge, at the very least, may very well kick the murder 2 case, the murder 2 claim, because there's no evidence of that at all. There really isn't. Whether you can prove that there was contact or not, how do you prove intent to murder? I don't even see how a reasonable trier of fact could conclude that. But I don't know. I mean, I think there's more problems than anything for the prosecution, and the defense hasn't even gone yet. So if the defense wants, if when they put on their case, if it just ends up being knockout punch after knockout punch after knockout punch, they could start calling back the prosecutor's witnesses just for fun.
Ashley Linnell
I,
says,
I would certainly have fun with a witness like Shannon Burgess. It's very rare that you get to just absolutely annihilate an expert.
yeah, I mean,
We
we only
all
show
had
you,
it a couple of times, but it's fun when you can pull it off. Generally, they're way too good and way too professional to have something like this happen.
right, like the neurosurgeon, which we'll get to. Ashley Linnell, do you think Judge Cannoni would have grave concerns if someone on the jury lied to serve on the jury? It is the same committing fraud on the court.
Yeah, absolutely.
Yeah.
That's a very, very good point and a very good comment. Because absolutely, you can't lie to courts. When you lie to courts, you get in trouble. You should at least. We'll see what happens. I think there's at least a possibility that when this case is over, they could sue this guy and this company for their money back.
Yeah, at
God
least
only knows how
get
much
their
they
money back.
charged. Yeah.
Let me ask you another question. Now that you spoke about Burgess, you spoke about Aperture, and we know that the Commonwealth's, what I believe is going to be their well, before this case, I said that the only way the Commonwealth conceivably can win this case is if they have an accident reconstructionist come on the stand and absolutely obliterate ARCA and show how ARCA is they're completely off their game. Their calculations are completely off. And, you get someone really credible, really qualified to walk through how this interaction could have happened. Now, we've been waiting on this. We've been hearing for months that this guy, this expert, is going to come and save the day for the Commonwealth is a guy named Judge Welcher. Now, it happens to be Judge Welcher works, and not only does he work for, he was apparently a vice president of Aperture. So before even hearing Welcher testify, which from the reports are we going to hear about him on Tuesday, does he stand any sort of, does he stand any chance of convincing this jury that this interaction happened? Or are they just going to completely say, oh, this is the same company, Aperture? Okay, we're going to be deaf to this testimony. What do you think about that?
Well, okay. I think Aperture is going to have some real problems. Okay. Now I'll reserve judgment until I see his testimony. I think that Burgess didn't do himself any favors because by the time they started talking about substance, I don't think anybody was ready to listen to anything he had to say.
And just to stop you for a second, Salman, because this really is Helen Lewis's question: is Justin Welcher's testimony going to be impacted by Burgess? So go ahead.
Yeah, I think it absolutely will, and I'll tell you how. First of all, there's the underlying question of, oh, this is the same Aperture that lied about Burgess. Okay, interesting. Let's hear what this guy has to say. And if I were the defense, what I would do with this guy, and again, you never really know, but this would certainly be a line of questioning I have lined up. I'd pull up his CV. I'd pull up his LinkedIn page. I'd pull up whatever's linked on his website. Those three things that they proved on Burgess was not true. I would ask him, is all of this true? Where did Aperture get this information? Did they make it up or did you provide it to them? Where does Aperture get information about experts? Does Aperture make it up or do they get it from the experts themselves? Does Aperture do anything? Does Aperture do anything to make sure you're telling the truth? And the thing is, the jury's going to know exactly what you're doing, and that's why I would do it like this, and ask a whole bunch of questions about that. Education. I pulled up Welcher's page right now on Aperture, PhD in biomedical engineering. Sir, do you actually have a PhD in biomedical engineering? Are you sure you do? You actually do, because Aperture had a different witness here who testified, who had something listed that wasn't true. You're telling us that you really do have this. Okay, excellent. How about an MS in biomedical engineering? Do you really have that? Which school do you have that from? How many years did it take you to pursue it? Did it take you 17 years to get that degree? And that's the thing. Bring it all back up again so that the jury sees that these two witnesses are the same company. Just kind of stick it right in their face so that they don't trust him because it's the same company. And at the very least, you can use his testimony if he comes across as credible, and he may. I don't know. We'll have to see. But you could definitely use his testimony to shred Burgess even more by asking him, where did Aperture get this information? Did you review it before they published it? And then you just kind of go that way. Now, it's going to be interesting to see, how this works. I think at this point, it's going to be important to point out that he's being paid by the prosecution and ARCA witnesses, even though apparently the judge is not allowing them to tell the jury who paid them. It's clear that the defense didn't. So that's going to certainly be an interesting point. but we'll have to see how this plays out. It's going to be interesting to see. I'd really like to see Walter's testimony, because at this point, I think the entire case hinges on it. The entire case hinges on his testimony being absolutely impeccable and perfect and unassailable. Every part of it has to be unquestioned, 100% true for the prosecution to even have a chance.
And there's already this huge problem with Aperture, as you just mentioned.
Yeah. They're walking up and down escalator.
Let me ask you another question. Talk about the neurosurgeon for a second. You saw the neurosurgeon testimony.
This guy was absolutely awesome. He's the kind of expert every lawyer wants. And unfortunately, sometimes we end up with Burgess. But this guy's the real deal.
And so what do you think in terms of the prosecution's case? Does he really help the prosecution's case? Does he support it? What just give us your thoughts about what he's done in terms of the way that he testified, the manner of his testimony. Is he believable? Is he credible? Has he completely debunked the defense's theory? What do you think?
No, I don't think he's completely debunked anything. I think he's helped the prosecution in that he helped further their theory, and he provides some evidence for their theory. And his testimony is completely unassailable. Let me tell you something. We've seen a lot of witnesses this trial. This guy did not embellish, exaggerate, or lie about anything. His testimony was 1000% true. Okay, he could have provided a certificate or a diploma from Yale, unlike Burgess. Okay, but I think that even though he helped the prosecution advance their theory, it doesn't really prove the case, in my opinion, because there's still plenty of questions that can be established. We'll talk about that more if you want. But B, and I think this is a real major point that I would hammer down if I'm the defense in my closing argument. He's an example of what a truthful witness looks like. He's an example of what a witness looks like when he's not trying to lie about everything and not trying to exaggerate about everything. In fact, I would probably tell the jury, the prosecution finally found an honest witness. That's why his testimony was so short. I didn't spend 3 days cross-examining him, because if I would ask him a simple yes or no question, he would answer it. Are you a forensic pathologist? No. See how easy that is? Did Buchanan do that? Did Burgess do that? Did Jen McBride do that? No, not at all.
Jennifer McCabe.
So I think that even though he helps advance their theory, he really hurts their case, because he shows the jury what a truthful witness looks like, in stark contrast to the rest of their witnesses, in my opinion, or the rest of their material witnesses, I should say. There were some witnesses that told the truth. There was a young woman DNA expert. I forgot her name. She came across as very truthful. I don't know how material that is. I don't know if that proves guilt. I don't think it does. But this guy showed us what a real expert looks like when he's telling the truth. And that hurts the prosecutor.
Amanda Kaplan, Welch's report at first was based on Jennifer McCabe's testimony. To Truth for Liberty, day 18 near end, Judge Canoni signals to prosecutor Hank with an O, objection hand sign to her cheek, and immediately grins big when Hank does object. I spoke about this before. I know, Sal, you don't really know what they're talking about. I spoke about this. There's at the end of the day, Judge Canoni puts her hand to her face, and there's an objection, and people are reading a lot into what happened. I know there's some videos made about that, but I think there's a lot of interpretation there, and I don't think you know what they're talking about. So we're gonna.
I think I'm picking up on what you're saying. I think what's being implied here is a suggestion that Judge Canoni is signaling to the prosecutor to make objections, and then she's sustaining them. Do I understand that correctly?
Yeah.
Impossible. I don't believe that for a second. Judges are sometimes stupid. Judges are sometimes biased. Judges are rarely, extremely rarely, that outright corrupt. It's almost impossible for a judge to be that corrupt. So no, I don't think she's signaling to the prosecutor to say objection without even seeing what happened. I'd be shocked out of my mind if that were the case.
Yeah. I mean, you got to be careful with some of these conclusions that people are making, and I know that
I understand why people would have that question, because she's made some very questionable rulings, very questionable, that I don't think she could justify if she ever had to. I mean, just those experts, the rulings that she made on Daubert back, with Crosby.
Right, and
that's still, I think that stands as the strongest example of a completely ridiculous ruling that just has two sets of rules for the two different sides. There's no way to justify it without, in my opinion, without the word bias being involved.
And we also, you know about the motion to dismiss, that there was no evidentiary hearing for those Brady violations. And
Right.
yeah, we spoke about that also. So yeah, I mean, I think we're just, you got to be careful with, you know, there's a lot of attention on this case and people are putting stuff out there. You just got to be, you know, take a step back and just be very careful about, you know, jumping to conclusions. Talking about that DNA expert, which you just spoke about. So let's bring this issue up. I think you're talking about Christina Hanley, maybe. And she, I think I may be mixing up her name, but what
She was a young lady. She was talking about glass and stuff.
Right. So let's talk about the glass on the bumper for a second, because what she testified to was that the glass on the bumper, remember there's a broken glass that was recovered from the scene that John O'Keefe was holding. Mm-hmm. And there's a lot of pieces of glass found around 34 Fairview. Now, some of these pieces of glasses were found on the bumper. Some of them actually made a 60-mile trip in a blizzard, being perched on the back of the bumper without getting thrown off, and also the piece of hair. But let's just, we spoke about that probably, but let's jump ahead to what she testified to, that all the pieces on the bumper, every single one of them did not match the glass. Now, some people are definitely people on the other side that think Karen Read is guilty have been saying, well, you know, just because you can't make a physical match of those specific pieces of glass, it doesn't mean that didn't really come from the glass. It's just that she couldn't make a positive identification for the pieces of glass, and really it's possible that they are consistent with the glass. So what's your thoughts about whether those pieces of glass do not match? And also, by the way, one of the pieces of glass that does match another piece of glass that was recovered from the scene, albeit not the drinking glass, they were both recovered by Michael Proctor.
That was exactly what I was about to ask you. If Michael Proctor touched this from the time the incident happened until the time this expert got her hands on it, it's all tainted and it's all meaningless. I don't think her testimony helped or hurt anybody in any particular way. The fact that she couldn't tell if it was from that or not, I don't think really helps or hurts anybody. I don't think her testimony did much to move the needle in any direction. I really don't.
Okay.
Unless I'm missing something. I didn't see any read. But again, what I think she does is she shows the jury how a truthful witness answers, which I think hurts the prosecution in the long run.
Yep. Okay, so moving on from the glass part, let me ask you about one other thing, because this is something that I've spoken about literally from the beginning, from day one. And I was saying that whether, you know, the prosecution has a real problem, because like you said, they got this Michael Proctor problem. They've got the boogeyman, they've got the villain of the case. And right away, you and I spoke about the fact that Hank Brennan did not mention anything about him in his opening statement, one of the first collaborations that we did. So he didn't mention anything about Michael Proctor in the opening statement. Alan Jackson completely, went to town on that, obviously. And now there are reports that Hank Brennan is actually not going to call Michael Proctor in his case at all. So how significant is that? And does that in and of itself, a basis to argue to the jury that there's obviously reasonable doubt here if they can't even have the confidence to call the lead investigator, which I know they're fighting back on a number of times in this case, but it was established that he is the lead investigator. He was the one touching all the, writing the warrants and touching all the evidence and sending them to evidence labs, etc. So what are your thoughts, just before I even lay anything else out?
I think this is a tremendous strategic mistake by the prosecutor. And again, Hank Brennan, his reputation precedes him as being an exceptionally good lawyer. I have some big questions about the way he's tried this case. There's a lot of strategic things that I disagree with. A lot of them I've vocalized on your channel. But if he does not call 3 witnesses that the jury wants to hear from, and that the jury will hear from, I think that is the biggest strategic mistake yet. Now, it's possible that he's throwing the defense off of his scent by making it sound like he's not going to call him. And really, he will call him, and he wants the defense to, not be ready, so to speak. But these witnesses are going to testify. And if the prosecutor doesn't put them forward in the way that they want, then the defense is going to put their testimony in the way that the defense wants. And when the defense wants, the defense can call them first, second, third. The defense can call ARCA first, the dog expert, create all this murkiness and all this dirt around the investigation about the case, and even more dirt into what Proctor did, and then call Proctor, and then just lead him with a series of yes or no questions, just hitting the points, just the big point after big point. Bring up the nudes text, right? Bring up the fact that, why he's no longer a cop and how that happened. But just hit the main points, a few yes or no. You can have him on the stand for 20 minutes and just do nothing but ground and pound. And then done. Thank you. I got nothing more for you. Now, it could be that the prosecutor is thinking that after the defense calls them, these witnesses, the prosecution gets to go and they get to bring up whatever they want, and they get to do it with leading questions. So it could be that that's what they're thinking, because typically you don't get to ask your own witness leading questions. But as a defense attorney, if I call the lead investigator, that's considered a hostile witness. I can ask him leading questions. The prosecution is now on cross-examination, so a lot of judges, and I'm sure Judge Coney will, allow them to ask leading questions by the prosecution. So it could be that's what the prosecutor is thinking. But I think it's a tremendous mistake not to call the boogeyman. You have to. You can't rest this case without calling him. You just can't do it.
And then they're also contemplating not calling apparently Brian Albert or Brian Higgins. Brian Albert, obviously the owner of the house, who didn't wake up from anything that was going on outside of the house. No idea where the dog was that night. Rehomed the dog, sold the house, made butt dials that night to Brian Higgins at 2:22 in the morning, or butt answers. And they're not going to call. I mean, again, these are the reports. Right. I don't know for sure, but these are the reports out there that they're not going to call these witnesses. And then you're just going to let the defense call these witnesses and say, Brian Albert, you made some butt dials at 2:22, right? You sold your house, right? You rehomed your dog, right? Right after this incident,
destroyed
right?
your phone. You destroyed your SIM card. First, you pulled out some messages, but not the rest.
That was Brian Higgins, right?
So, and the last time you testified, you had a lawyer here, right?
Nothing further.
A criminal defense lawyer. Thank you. Nothing further. That's done. He's shredded. There's nothing left of him. As opposed to the prosecutor bringing it out and trying to get ahead of these things. I say this all the time. I said this on your channel. I've said this other places. If you have a bad fact on your case and you're the plaintiff, you have to put that fact in front of the jury. You have to. Mm-hmm. That way it's put in front of them the way that you want it put in front of them. So if he doesn't call them, I'd be very, very surprised. And I'd really be curious what the strategy is, what the thought process is.
Here's another witness that apparently we're not going to hear about from the prosecution. And some of you probably don't know about this witness, but how do you question Officer Nicholas Barros? He said testimony that the taillight was cracked. He came actually to Karen Read's parents' house, where the car was eventually towed from. So it was after everything that happened the night before, after the whole 5 o'clock in the morning search, after everything. He comes in the middle of that, or the tail end of that huge blizzard, and there's some footage of her car actually getting put on the tow truck, and this officer was there, Nicholas Barros, and his testimony was that the tail was cracked but not completely broken. Do you think the defense will be able to meet with Barros before his testimony?
I don't think there's any chance that he'll meet with anybody before he testifies. But I'd certainly call him as a witness. Again, it creates more question marks. It's very significant. Yeah. Very interesting point.
Slinky 20. And again, last trial, the prosecution, Adam Lally, called that witness. So as much as people are saying, Adam Lally didn't do such a good job, he actually called these witnesses. He called Brian Albert. He called Brian Higgins. He called Michael Proctor. Right. And if Brennan doesn't do that again, we both think it's a mistake.
I think it's a big mistake not to. Whatever you gain by being able to ask leading questions, you lose by the defense being able to frame their testimony however the defense wants.
Slinky 2021 says Solomon would need to see to believe. Some believe unless he stood back to show it. She immediately called sidebar. So again, this is talking about that suggestion that Judge Canoni signaled to the prosecution to make an objection, and then they called the sidebar, and then that was the end of the testimony for today. And some people believe that unless he stood back so the cameras can catch all this, I think there's a lot of jumps here, and you got to be careful with this. I know that when you look at this trial with a certain lens on, you start seeing things and you start making certain conclusions. But I think you spoke your mind about that. Not Sarah Lee says, no joke at this point. I'd not be surprised if some of the jury think Proctor has passed away because of how elusive they've been about him so far.
Maybe.
On Wednesday, Karen Read said the Commonwealth has one witness left. So, again, I don't know where she's getting the information from. And until the Commonwealth rests, they can always revisit and decide they're going to call people. You know,
I think it would be such a strategic mistake for the prosecutor not to call these witnesses. I'd just be shocked.
Yeah. Okay. Let me see if I have any other questions. And I want to play for you one other clip. But I want to get to another question or two before we do. We still have a little bit of time. But the chat is very active, obviously, and it's hard to find all the questions. We'll do the best we can. Yeah, a lot of the questions are very similar to things that we already covered about, you know, how much it damages Aperture, the fact that Burgess testified already first. Okay, so let me play this clip for you. One other clip that I want to play, and this has to do with some of the clips that Hank Brennan is playing. And I think we've spoken about this before, and I asked my guest last Friday, Mark Bedero, about this. Let me get your take on this. Hank Brennan keeps playing some of the clips that Karen Read gave interviews to. Mm-hmm. And we'll play it in a moment. But as the rule of completeness, as you know, allows the defense to present these clips in context. And I haven't seen anything like that. I haven't seen that they're playing longer clips and it seems that maybe the defense is going to play some of their own clips. You know, what would your strategy be when he's taking these 3-second clips, strategically playing them throughout the trial at different moments, which he thinks is helpful for his case. And, you know, what would you do about this rule of completeness? Do you demand that they play the entire docuseries up front, all hour and a half of it? I mean, like, what do you do about that?
So this is a clip by clip analysis. It's very interesting. I've had this happen a couple of times. If I think that I can prove that the prosecutor is intentionally misleading the jury, then what I would do is I would find the strongest example or two, and then in my case in chief, I would play the clip, and I'd probably play the clip a second time as presented by the prosecutor, and then I would play it under the rule of completeness, what it really shows, especially if it's a very strong contrast and completely says something different, because then it just makes it look like the prosecutor is intentionally misleading the jury. And if you can do that for 1 or 2 clips, you don't have to do it for the rest. You could do it for the rest if you want, but what I would do, again, is I'd find the 1 or 2 strongest examples of this is clearly intended to mislead the jury, and I'd play the clip as played by the prosecutor, and then I'd probably play it a second time, and then I'd play it showing the real context. And if you can do that, you're really, really in good shape. I did this once in a case where
I know
the defense attorney showed a few lines of testimony.
Yep.
And then that was it. And then what I did was I blew that up and I showed the jury, the defense attorney showed you this to make it look like my client's a liar. Remember that? And they're all nodding their heads. And I said, let me show you what she didn't show you. And then I showed the whole statement. And then I read it to them slowly. And then I had both up right next to the jury so they could see the difference. And I didn't have to say anything else after that, because at that point they thought the other attorney was a liar.
That's all you need.
That's all you need.
Valerie says, do you think this could be a slip and fall accident?
And it'd be a pretty bad fall. People fall on ice all the time without dying. But I guess it's possible.
Here's a question from the Great 99. Did Burgess write his new report on his own, or did Hank tell him to? What do you think?
Very good question. I think it's inconceivable that any expert in the middle of a trial would write his own report without being asked to. It makes no sense at all. Anybody who's ever hired an expert knows that you don't just write a report on your own. And again, this is a point that if the defense wants, they could bring out from Welcher. They say, when you write a report, do you just write them on your own, or does the attorney ask you to? This is something that they can ask their own experts. How long have you been testifying? How long have you been doing this? How many cases have you worked on? Have you ever in the middle of a trial just sua sponte written your own report?
Oh, by the way, Solomon, that was actually a question that was asked on cross-examination. How many
really?
times? That was unless he asked him.
That's
How
right.
many
That's right. And he
times?
said never. Yeah.
They're like, oh, this would be the first one.
Yeah. And it also started with, "Dear Mr. Brennan, as you requested," or something like that.
Right, per your request. And then you said he copied and pasted that part.
Right. It's just, it's inconceivable that he would change his report in the middle of a trial without being asked to. It's inconceivable. And again, this is something you and I know that the jury may not necessarily know, because you and I deal with this kind of stuff all the time.
Yeah, we can't get an expert to talk on the phone without getting billed for that and exactly what they're doing and the scope of what they're doing and talking. Yeah, Nikki, would you both still not call Karen to testify? I know my answer, but I'll let you take this, Solomon.
There's no way in the world I'd call her. There's no reason to.
Exactly.
You've got the case won. There's just no reason to. I don't think she's likable. I think she's got some problems. And, something that I've learned a long time ago, and I've seen this happen, is as a lawyer, you have to know when to shut up. And obviously, you have to know when to tell your client to shut up. If, let's say, you're in a position, you're in a hearing, and we've all been there, where the judge is going to rule in your favor, and you can tell the judge is going to rule in your favor, but then the judge will turn to you and say, "Anything else you want to say, Mr. Radner?" The answer is no. Even if you can make a really good, strong, compelling argument. There was one time a perjury case I was working on where the judge was about to dismiss the case. And I could tell the judge was about to dismiss the case because he was arguing with the prosecutor about it. And then after he got done arguing with the prosecutor, he looked at me and he goes, "Mr. Radner, any oral argument you'd like to make?" And I said, "No, Your Honor." I sat down and my client started slipping me sticky notes. And then I just whispered to him, "Does it look like we're losing?" So he sat there and he shut up, and the judge dismissed the case.
Yeah. So there's no reason, no reason at all.
There's so much reasonable doubt already. All she can do is hurt you. She's not going to create more reasonable doubt. I don't think she's particularly likable. So why take the risk? Why take the risk?
Yeah, totally not necessary. CJ Coop, it just comes down to common sense. An arm didn't shatter in 47 pieces or shatter a taillight in 47 pieces. Look at the injuries. We shouldn't be here, full stop. And I think, Salman, you've said this.
No question about it.
Question from Slinky 2021. What do you think about Colin's knuckles and his bragging, also wearing a prison suit at Halloween? So this is Colin Albert, who's not testifying, and he's not going to be able to be called in the defense's case. So it's not going to be relevant for this case. But there were some pictures of Colin with his knuckles banged up, which he claims happened a few weeks later when he fell down, whatever. And then also he wore a prison suit on Halloween. So
more question marks. More question marks.
Let me play for you this clip. Okay, and this is, again, look at the date here, June 15th, 2024. Okay, so again, this happened January 29, 2022. So this is 2 years later, and just as a little bit of a setup for this, just set the stage, we have data that Karen Read's phone connected to John O'Keefe's house Wi-Fi at 12:36. And this was brought out by a Commonwealth expert, or I should say Trooper Garino. And now we're going to hear what she has to say, or what her memory is of when she got home that night.
At 12:41, I leave a voicemail to John where you can clearly, and this will probably be played on Monday, you can clearly hear me pull into John's garage. You can hear my car sensors beeping as I come close to the sides of the garage. And then you hear the car go off, and then you hear the slight ding, ding, ding as I open the door, shut the door. I had high heels on the night. You hear me walk in, go into the stairs up into the kitchen, shut the door. You hear me walk in the kitchen. It's like a full minute long. That's at 12:41.
So the reason why he played
was that a voicemail that was played?
That wasn't a voice. There was a voicemail that was played, but she's talking about the voicemail that was played. And she's saying
what
that
time was that voicemail left? What time was the voicemail left?
Voicemail was at 12:41. And then so now the reason why
the voicemail was at 12:41, and you can hear all that stuff that she's describing at John O'Keefe's house.
Right. when she's
And the
walking into
Wi-Fi
John O'Keefe's
connects
house.
at 12:36.
12:36. So he's playing this obviously because he needs to help on the timeline, because if this happened, if the interaction between Karen Read's Lexus and John O'Keefe happened at 12:32 in like 16 seconds.
And she wasn't at John O'Keefe's house at 12:36. Right. That's clear. So the question, but she could have been there by 12:41.
12:41 would
So-
give her some more time to get there. So here
Well, then
she's
this is
saying
a
that
real question mark. So how do you reconcile this? How could the voicemail have been left at 12:41 and the Wi-Fi connect at 12:36? That's not possible.
well, the only way that's possible,
where were the timestamps from? Where's the 12:41 timestamp and where's the 12:36 timestamp?
well, from her phone records, there's the 12:41.
Both are
but
from her phone records.
both are from her
There's
phone
one
records.
from John O'Keefe's Wi-Fi records.
Right. So that, well, I don't know if it's from John O'Keefe's Wi-Fi records, but you can tell from her phone that she connected to John O'Keefe's Wi-Fi at 12:36. So some people suggested that she's sitting in the driveway for a few minutes, texting and calling.
Oh,
and
that's very possible. So she's called. That makes sense. That's the only thing that makes sense. The bottom line is she didn't hit him at 12:32. That's what this establishes. There's no question about it, because it doesn't take 4 minutes to get there. It's usually. I thought I saw that it takes 6 to 8 minutes. Is that what it is?
Right. Yeah.
6 to 8 minutes to get there regularly. Now it's dark and snowing. She's drunk. I mean, I don't know if that helps or hurts, but if it's a 6 to 8 minute drive and now it's dark and snowing, you're not going to get there in 4 minutes. So there's no way she hits him at 12:32 and gets there at 12:36. This completely blows up the prosecutor's timeline. Completely. This
Right,
may
well,
be a
he's-
basis in and of itself to either find not guilty or to grant a directed verdict, because it's inconceivable at this point. You cannot be in these two places at these two times. It's just not possible. But we know for a fact that she's connecting to the Wi-Fi at 12:36. As far as the 12:41, yeah, it's possible she's sitting in the driveway. It's possible that she pulls in front of the house, makes the phone call, or connects to the Wi-Fi, and then is sitting there and gathering her stuff and, being angry and who knows, and then makes the phone call 5 minutes later. It's possible. That makes a lot more sense than anything else. But there's no other plausible explanation for the Wi-Fi connecting at 12:36.
Right. I
That,
don't think
blows up the prosecution bigger than anything else.
Brennan's going to try to make the argument that you can't trust the Wi-Fi data, right? So,
Then how's he going to explain this? He's going to say that she did an 8 minute drive in 4 minutes.
I guess that, or that the Wi-Fi is wrong, or that data is messed up. Maybe there's a variance there.
That's possible. So that's why I'm wondering what the source of the data is. If you would look at it right now and it's 5 minutes behind,
it's the same source. It's all from her phone.
then you can't answer it. You just can't.
Yeah.
That's a real problem for the prosecutor.
Gladys Kravitz, Hank knew about his education. He asked about all his credentials except his education on direct. He didn't ask about his education on direct.
I didn't catch that.
Next
Good
witness, he
catch,
asked all about
Gladys.
his education.
Then it could be that I don't think Hank would hire an expert knowing that he's lying on his resume. I think that if let's say he learned this in the middle of the trial, it could be, for example, Burgess called Hank and said, "By the way, I just want you to know I don't have a bachelor's degree." And then they had an expletive-filled conversation, and Hank came up with a way of presenting it. That's possible, but I don't know. Again, question marks help the defense.
You see, yeah, exactly, and that's what Mark Better was also saying. That the more questions you have, the more it helps the defense. He did say, just to be fair, he did say that Burgess submitted his CV in October of 2024, and in that CV he said that he's pursuing a bachelor's. Now, when he was hired to do the work, I'm not sure if Brennan maybe knew that, and maybe he only got that CV later. And I don't know if he specifically asked for Burgess. It could be he just contacted Aperture and say, "Hey, I need these two types of experts. You got 100 of them. Give me 2." And they gave him Welcher and Burgess, and without realizing it until trial was coming closer, that's when he realized, wait a minute, you're only pursuing your bachelor's. So just to be fair accurate about what happened. Big fan of justice. What are the elements of the charges, and which of them has the Commonwealth has proven? Well, I know what you believe. You believe that they haven't proven any of them. Also, after the ending of the trial, no matter the outcome, will the gag order still stand?
After the case is over, will the gag order stand?
Right.
Almost never. I'm not going to say never because I don't know offhand if I've ever heard of a case where a gag order survives the verdict. I don't think it does. I'm pretty certain.
What about if there's a mistrial again?
Doesn't matter. Doesn't matter.
That,
I mean, the only thing potentially would be for the jurors.
Well, if there's a mistrial, maybe the judge doesn't want the lawyers talking to the press, assuming there's going to be a third trial in this case.
That's possible, but then the case is still pending. Once the case is over, you can't put a gag order in place.
I mean, if there's actually a verdict of guilty or not guilty, then there's not going to be a gag order.
Right.
Question from TCP. Given that the experts are sequestered, how much prep can Hank do with Welcher with regards to Burgess? Good question.
Given the experts are sequestered, how much prep?
Because Welcher was not allowed to find out any sort of information about Burgess. That's a great, great point. He has no idea about what happened to Burgess on the stand.
I don't know who TCBDKK is, but that is a brilliant point. Absolutely brilliant point.
It's a great point.
Yeah, it's going to be interesting, and I guess that's something the defense is going to have to bring out, especially if the prosecution and Welcher get ahead of this. Say, are you aware of what happened with Mr. Burgess? And if he says yes, that establishes that they've been violating the protective order. Or the
because just thinking about it now off the cuff, I'm thinking, if you just pulled up Aperture's website, and it says that they amended they changed his education. Now, this is the vice president of Aperture. Do you know what's going on at Aperture? Do you know that this change was made? You don't know that this change was made? How would you know that this change was made, and why was it made? And if that comes out that he violated the sequestration order, then that'd be real problems. Right?
Yeah, certainly would be.
That's a great point.
Yeah.
Cloak and Glommer, a lot of respect for Solomon. Heard about him many years ago related to Joanne Romaine and police cover-up. He knows what he's talking about for sure. Do you remember the Romaine case?
I remember it very, very well. Very, very devastating case.
Was that the one? Where was it? All the way up north? Oh no! I know the Romaine case.
This was the one where a woman was abducted and murdered, and her body was found 3 months later. And the police, within 10 minutes of finding her abandoned vehicle, determined that she had committed suicide by walking out into 2 feet of freezing water and drowning herself, even though there was no body and there was no proof that she was in the water. They were able to establish within 10 or 15 minutes of showing up and seeing her car parked in front of a church. She parked here, walked out into the 2 foot freezing cold water, and dunked until she was dead. Covered it up as a suicide. We felt very strongly that the police covered it up. We felt that we established that the police covered it up. Unfortunately, what the Court of Appeals essentially held was that even though there's certainly a lot of problematic questions, there's no proof that the police were involved in her abduction and murder. And a cover-up is not a cognizable legal claim, which shocks a lot of people. You would think that if you can prove that the police cover up a crime, that you could sue the police for that. But it's virtually impossible to sue the police for a cover-up.
I remember that
devastating case. We could do multiple shows on that case. That case went on for probably 6 or 7 years. That was a devastating case.
Wasn't there a Netflix series about that case, or they were talking about doing that?
There was. What was the Netflix show? Unsolved Mysteries, I think it was called. I think it was called Unsolved Mysteries, Lady in the Lake, or Murder in the Lake, or something like that. I haven't looked at it in a while. I'm still in touch with the client occasionally. It's a devastating case. This is one of those cases that really kind of shakes you up as a lawyer.
Yeah,
it stays with you.
I remember that case. I have extensive experience with Wi-Fi router firmware. The timestamps do not lie.
Yeah, that's kind of what I was thinking too. That creates major, major problems for the prosecutor.
Mr. Meathook, no question, Karen is not guilty, but in the interest of full disclosure, I dated a girl like her once for 4 hours and 51 minutes.
Interesting.
Rainy day. I think Hank put Garino early to try to bury the 1236 Wi-Fi connections. You're not going to. Yeah, I know.
It's not going to happen. The defense is too good in this case.
Exactly. All these things, like you may get away with a novice defense attorney, but not this team. You're not going to get away with any shenanigans with them. Expert witness for hire. In 911 call, Jennifer McCabe stated John O'Keefe found on stomach and turned over for Karen Read to start CPR. How can debilitating head injury happen that he turned over to his stomach? Yes, I know that this is people talking about that he was turned over. So that would definitely be a question to be asked. How do you end up that way? And how do you end up on the stomach? Landed on the ground.
Self-defense.
And again, exactly. Question mark self-defense. I mean, according to the neurosurgeon, he landed on his head. That's how he died. And then somehow he got turned over. But, yep, that's exactly the problem. Okay, well, that looks like the extent of the questions. I know there's some more questions we didn't get to, but we're getting into the hour and 15, which Solomon starts to charge me the heightened fees. So we are going to thank Solomon for all of his time today and for feeding our addiction on this case. And we're going to have something hopefully special for you guys tomorrow. May not be in the form of a guest, but hopefully be in a video. But thank you again, Solomon, for joining us. And hopefully we'll see you again maybe next week.
Always nice to be here, Martin.
Thank you. All right, well, there it is. That's Solomon Radner, Brother Counsel's Brother Counsel, the national trial lawyer. He's got a lot of experience in trials, a lot of experience with police, a lot of experience with exposing some cover-ups and corrupt police. So he knows a thing or two around these type of facts and scenarios. So that's going to be it for now. Again, hopefully we're going to get something out for you tomorrow. And if not, then we will be back here Tuesday morning for the live stream starting 9 a.m., which we're probably going to see Judd Welcher take the stand. And we'll see if the Commonwealth or Hank Brennan decides to call actually Proctor or Brian Albert, Brian Higgins, some of the other people that are involved in this case, which according to everyone who's been talking about this case, that's the right move. If you want to try to win this case, you got to call these witnesses that are not such great for your case because you just got to get in front of it. So thank you all for joining us today, and we will see you next time. Take care.